A very good evening to all of you, and you're joining in with the Law and Order program for this week. And we are happy to discuss about administrative law with special reference to law of writs. And today at Channel I studio, we are happy to welcome Mr. Shanta Jayavarthan, attorney at law, for our discussion today.
Thank you very much, Shah. Thank you very much for the invitation.
And we would like to post a question at you. Firstly, what is administrative law and what areas does it cover?
Administrative law governs the relationship between the citizen and the government, and the government institutions. So it is a body of principles and concepts developed by court as to how the relationship between the citizen and the government should be. So that's in if I may put it simply, that is what is administrative law. Those are certain concepts developed by the courts. Now, if you take fundamental rights, there are certain rights recognized, but these concepts are developed by courts.
So, administrative law is not necessarily found in a particular act of parliament, but rather developed by case law.
That is so. It's a body of law developed by way of case law. Of course, when you deal with administrative law cases, almost all the statutes come into play. So it's around the statutes. The principles are developed in interpreting the statutes, because the basic focus of the administrative law is to keep public authorities within their statutory limits. So the public authorities have various powers. For instance, if you take the Central Environmental Authority, they have the power to issue licenses to carry out certain projects, to engage in certain businesses. So those powers given to public authorities have to be exercised within the framework by the person to whom the power is given by the statute. So if a public authority or a public officer exceeds the power given under the statute, then the courts will intervene. The courts exercising the powers of judicial review, in our case the Court of Appeal, will intervene and try to put back the authority back in place. So to put back within their powers. So that is one aspect of administrative law. Then of course the other aspect is, if a public authority does not carry out its statutory or public duty, then also the public law principles will come in. Then the court can compel the public authority to discharge its duties. So then around those there are several principles and concepts developed. And also how the court decides whether authority has exceeded its powers. That there are several tests. If, for instance, if a public authority does not have the power to do certain things, then of course that decision is, the court will invalidate that decision by way of a writ. Then of course there are certain instances where a public authority follows a wrong procedure or an unfair procedure. Then again the court can intervene and quash or cancel the decision by a writ. Then also the third instance is where the decision itself is wrong on merits. Then also the administrative law principles will come in, and then is interpreted to mean that the decision is without power.
So the administrative law is there to tell public authorities, public institutions, government bodies as to what exactly they should do and what exactly they should not do. And when it comes to an infringement, for an example, let's take a situation where a particular government body has overstepped their boundaries and they have done something which is going against their limits.
Yeah.
What remedies does a person who is affected by such a decision have?
Yes, if there is a decision which is against the law, which is without the power, in excess of powers of the public authority concerned, or if it has been done following a wrong procedure, for instance, if the party concerned is not heard, or if the decision itself is wrong on merits, then you have to challenge it by, we call it a writ of certiorari, that is to quash the decision, to annul the decision, to invalidate the decision. So then you have to go to the court, the relevant court, that is in our case it is the Court of Appeal. under Article 140 of the Constitution, the Court of Appeal has the power to issue writs. Then in certain instances where the powers are with regard to the provincial authorities, provincial powers, if it's a provincial authority, then you have to go to the provincial high court and ask for a writ. So, if it is to quash a decision, you have to go and ask for a writ of certiorari, which we call it a writ of certiorari, but and also in a non-legal language a quashing order. The court will quash, annul the decision. Then that is how the decision is challenged. A decision already made is challenged.
And also, you spoke about a writ of certiorari. What exactly is meant by a writ? Now, this is rather new to the vocabulary of a ordinary person.
Writ means a court order, which a court decree or a court order simply. So, it's the legal jargon. When you say a writ of certiorari, it's the legal jargon, but in effect what will happen is the court will invalidate the decision of the decision maker. For instance, if there is a project affecting the environment and then there is an environmental impact assessment done and the public is not given an opportunity to comment on the public environmental impact assessment report, then for instance a permit issued on that basis, on the basis of that impact assessment report can be quashed by court. So, when you issue a writ of certiorari, you quash that permit or a document or the decision.
So, a writ of certiorari is one remedy.
Yes.
What other remedies are available
Yes.
along with
Then,
writ? Because Article 140 also
yes,
specifies
yes,
a series
yes,
of writs.
Yes. One, the first is the most commonly referred to is the certiorari. Then there is the writ of mandamus. What writ of mandamus does is to compel a public authority to do something which they are supposed to do under the statute, which is relevant. For instance, if a simple example would be if the police doesn't arrest a wrongdoer in case of if somebody has made a complaint and the police is not taking action, then you can compel the police to take action, to take legal action, to arrest or produce a report facts to court, can compel. And also maybe the same, if you take the same example, Central Environmental Authority, if there is an activity without a license for which a license should be obtained from the environmental authority or a local authority, if the environmental authority does not take action, then you can ask for a writ of mandamus from the Court of Appeal to compel the environmental authority to take action. So, mandamus is to compel to do a public or a statutory duty. Then writ of prohibition is a bit like certiorari, but you ask, the stage is different. Prohibition, you prevent a person from doing before it's done, but certiorari is after it is done to have the decision annulled. So, as far as certiorari and prohibition is concerned, the same principles, more or less the same principles applies. So, the stage is different. A writ of prohibition prohibits a public authority from doing something illegal. Then there is writ of quo warranto. If somebody is holding a position illegally, to remove him from office. Say somebody who is disqualified to hold office as a member of parliament is elected to parliament, then you can ask for a writ of quo warranto to remove him from office. So, a writ of quo warranto requires the holder of a public office to show under what authority he is holding such office. So, then there is writ of habeas corpus, which is also very vital as far as the liberty rights are concerned. If somebody is taken into custody by a public authority, then you can ask for a writ of habeas corpus directing the person who is having custody to produce him in court. So, for instance, if the police takes somebody or the or a military authority takes somebody to arrest and then we don't know whereabouts, then we can ask for a writ of habeas corpus directing the police or the military or any other public authority to produce the person in court. So, those are the 4 basic writs. Then of course, there is a writ of procedendo, which is not commonly used, which is to direct a public authority to proceed with a certain action. So, those are the five principal writs issued that we can ask for from a court of law. Basically, from the court of appeal, if it is within the powers of the central government, but if it is within within a provincial, if it is done by a provincial authority in respect of a subject given to a provincial council, then you have to go to the provincial high court. But of course, even in respect of a provincial authority or a provincial subject, the court of appeal has the jurisdiction to hear a matter arising out of a provincial issue as well. But of course, most commonly practically go to the provincial high court, which has the same jurisdiction.
Now, you elaborated on the law of writs, particularly emphasizing on Article 140. In addition to law of writs, what other remedy or what other instances can a person go to courts under administrative law?
For instance, the fundamental rights jurisdiction is bit similar to writ jurisdiction as well. Of course, the principles developed in administrative law is now most commonly applied in fundamental rights applications as well. For instance, concepts like unreasonableness, irrationality are used in Article 12(1) cases, in Article 12(1) fundamental rights cases. So, there are some concepts overlap, but in fact the writ jurisdiction has kind of enriched the fundamental rights jurisprudence as well. So, there are certain issues that we will have both remedies available. Perhaps will be able to go by way of a writ as well as a fundamental rights application as well, but that depends on for instance, unlike in a fundamental rights application, in a writ application you can't ask for compensation. So, that being the difference, then there are various other tribunals in which you can seek similar reliefs. For instance, for public servants there is the Administrative Appeals Tribunal to make appeals. It's an appellate forum, but more or less they apply the administrative law principles and in certain instances constitutional law principles as well. So, to the administrative tribunal you can appeal from orders of the Public Service Commission or the National Police Commission. In respect of police officers, then there are other tribunals like the University Services Appeals Board, where university employees can appeal. So, there are various administrative tribunals like that. So basically the writ court, the court of appeal, and provincial high court. Then of course there are tribunals, administrative tribunals, in which you can seek certain relief.
So, you spoke that in a writ application you can only seek a particular action to be cancelled or for a government officer to do something, but you cannot ask for compensation.
Yes.
So, in an instance where a government body has taken a decision and which is going beyond their powers, and also it has violated my right and caused a damage to me, how can I claim compensation for that?
Yeah, in a writ application you can't ask for compensation as a relief. Of course, the Constitution gives the Court of Appeal the power to refer certain matters to the Supreme Court. If the Court of Appeal in hearing a writ application finds that there is an infringement of fundamental rights, the Court of Appeal itself can refer the matter to the Supreme Court for make a determination on whether there is a violation of fundamental rights. Similarly, even the Provincial High Court has the same power. If they find in hearing a writ application, if they find there is a violation of fundamental rights, they can refer the matter to the Supreme Court. So in those instances, the Supreme Court will have the power to grant compensation, but in a writ application you can't directly ask for compensation.
And also, when it comes to administrative law in general, there is also a concept called legitimate expectation. Is legitimate expectation practiced in Sri Lanka a lot, or is it something limited to the books?
No, it is practiced, Shahar. Before that, I think I'm able to go back to the grounds on which we can ask for a writ of writs. For instance, we must, as I said earlier, if the authority has no power, if they've acted without power, then you can ask for a writ. Or then if the public authority has acted in a procedurally flawed way, for instance, if the parties aggrieved are not heard, we call it the natural justice. If the persons affected are not heard, then you can ask for a writ. And or similarly, if the decision maker itself has an interest in the matter, we say it's bias, and then there are the legal principle of nemo judex in sua causa. Those are, the first is a jurisdictional, we say it a jurisdictional ground where there is no power. Then the other grounds are procedural. Then there are substantive grounds like unreasonableness, irrationality, failure to take into account the relevant factors. So, legitimate expectation is one of those grounds, emerging grounds of challenging a substantive decision. What it means is that if a public authority or a public officer has promised to act in a certain way, and then for without valid reason has then acted in frustration of the legitimate expectation, then you can complain to the Court of Appeal, and in fact it has been effectively used in several cases in Sri Lanka. For instance, there are reported cases like multinational property development case, where a property developer went against a public authority, where it had been promised to grant a particular land on a lease, and then the government the authority went back on it. Then the court held that his legitimate expectations are violated, the company's legitimate expectations are violated. So, it has been enforced and recognized by our courts, and it is an emerging ground. Of course, now it is well recognized as a ground of review. That is one of those substantive grounds, Chair, on which you can ask for a writ.
And also, when it comes to administrative law and the purview of administrative bodies in general, we also discuss about rules of natural justice.
Yes.
Now, rules of natural justice is not found in a particular act or a statute. It's more derived from English law.
That is so. That is something so natural. That is what is in fact called natural justice. So, there are two aspects in natural justice. In fact, I refer to that briefly. One is that if a decision maker or a public authority is going to make a decision, then the decision maker has to hear the parties who will be affected by the decision, and as well as the complainant. So, he has to hear both sides, the complainant as well as the others who are affected by the order that the decision maker is going to pronounce. So, the first aspect of natural justice is to hear both parties. Then of course, the second aspect is the decision maker should not have any interest in the subject matter. If he has any interest, then he shouldn't be the decision maker. So, those two are the two basic principles of natural justice. Then of course, the third one is the right to reasons, that the decision maker must give reasons, which is also recognized as part of natural justice. So, violation of natural justice is a procedural ground on which a decision can be challenged or quashed by a court that has the power to issue writs.
And also, now I would ask you a question again, not as a lawyer, but also a citizen and an activist who is passionate about justice in Sri Lanka. The purview of administrative law is mostly, there is an allegation that it's limited to people in Colombo, and a lot of people who are not well off do not use remedies of administrative law. Is it because litigation is costly, or is it because of unawareness, or is it because they prefer not to enforce their rights?
For first two reasons you gave, I believe that's one is the cost factor, the other is the lack of awareness. But my experience is that there are a lot of cases filed by farmers, by people living in rural areas in respect of state land. For instance, under the land development ordinance, land is given to farmers and other communities for instance to live or for commercial purposes or for agriculture. So, then there are a lot of decisions made by the division secretaries with regard to the rights, the devolution, whom the land should go after the death of the original permit holder. So, quite a number of cases relating to state lands, which basically from people from various from faraway places, from remote areas, not very much educated, but they eventually they come to court. But there are quite a number of cases on state land, but apart from that, I don't see them coming forward often on environmental issues or other issues that affect them as a whole. But for individual cases, in particular land issues, they come to court. That is my experience.
And also, again, as a citizen, do you think Sri Lankan students should be given the education and knowledge about the basic aspects of law, and even people in general should be made more aware of the law in general?
Of course, yes, of course, that has to be done. It's even any subject better if you know it. So it's actually a good thing if it is to be, if certain the basic concepts are included into school curriculum, perhaps basic concepts, perhaps a bit of public law, and maybe need a bit of commercial subjects as well, given the modern circumstances. So yeah, it's a must. Actually, we are late. We should have done it maybe 30-40 years back.
Few decades ago.
Yes.
And also, before we wind up, I would like to ask you, now the law relating to administrative law deals mainly with government bodies, and so they are mostly only about how a citizen interacts with government bodies. But if any of these legal duties, or for an example, if rules of natural justice are violated by private bodies, let's say a company, for an example, violates the rule of natural justice, or a company violates the rule of bias, then what remedy do you have? Can you go to the appeal court just like a government body, or what remedy
That
do you have?
depends on, there are very few instances where public institutions, so private institutions have been brought under jurisdiction. But of course, where, for instance, there is one case where a private bank, private banks in case of an auction, there is a parate auction, they resort to the statutory procedure. So then, of course, the court said, because they rely, though the entity is private, but they exercise statutory powers. Therefore, they are amenable to writ jurisdiction of in that case of the Court of Appeal. So yes, there are certain instances where you should be able to, but it will be very difficult. But depends on the nature of the institution and the function. Because in English law, of course, now there is a developing concept of public function theory, where you look at the function, and if the function is more of a public nature, then although the body is private essentially, if the function is more of a public nature, then perhaps we should be able to try it. But I believe there are a few instances in New Zealand where the New Zealand Rugby Union was taken to court by a writ application because they perform a public function of selecting players to represent the country. So that argument is there, that development is there, even that I believe the New Zealand case is maybe 20 years back. So that development is there, but we also have had, I believe, at least one case where a private entity was brought into court by a writ application. Then I also believe, my memory is correct, there was another case against the National Olympic Committee, which is
also a private body.
Sort of a private body, but performs a public duty. So there is an argument for that, but we'll have to keep pushing the boundaries and to keep fighting in court to succeed.
So that's why we need activists to
Yeah.
push forward the boundaries of law. And with that note, we would like to end today's discussion on law and order, where we discussed administrative law with special reference to law of writs. And we would like to thank Mr. Shantha Jayawardena, attorney at law, for gracing this occasion to the Channel I studio.
Thank you very much, sir, for having me in this program.
And we would like to thank our viewers for your viewership, and we wish you a pleasant night.